Hello, I'm Michael Wax. In this video, we're going to discuss depositions. A deposition is a pre-trial discovery device that both sides in a civil litigation lawsuit have an opportunity to use. It's the time when both sides get a chance to see the other's witnesses and the other parties to get the information from them that will be used at the time of trial. In civil litigation, there are no surprises. Unlike criminal law, where there can be lots of surprises, in civil litigation, both sides are supposed to show their hands, and that all of the witnesses that they have, all the evidence that they have, is provided to the other side. And each side gets an opportunity to take the deposition of the other side's party, as well as the other side's witnesses. And this is something that is done in a deposition. A deposition is done in a room, usually in a conference room at one of the attorney's offices. And it is done with a court reporter. It's just like testifying in a court of law. The penalty of perjury applies. It is just as if you were testifying in a court of law. The court reporter is there, who is going to be taking everything down that is going to be said in the room, everything that is going to be said by the attorneys, as well as the witness or the deponent. Everything that is said in that room is going to be transcribed into a booklet. And the deponent, the witness, gets an opportunity to review that booklet at a later point in time, and they can make changes to that booklet if they so desire. It's very important, however, that you don't make significant changes. You don't make huge changes, such as if the attorney asks you, what color was the light when you saw it, and you say red at the time of your deposition, and then when you change it later, you change it to green. That's a significant change, and that can be pointed out at the time of trial, so it's really important that you try to give your best testimony when your deposition is taken. The questions that are asked at a deposition will cover a variety of topics. They usually go back into your basic background, your history, your education, your work history, then details about the accident, the injury, how you're feeling, and what doctors you went to. The deposition is kind of like a fishing expedition. So there are probably going to be questions that will be asked at a deposition that you as the deponent may be saying to yourself, why is he asking me that? And if your attorney is not objecting to those questions, chances are, assuming your attorney is not asleep, that the questions are appropriate. And if he is objecting to those questions, then they're not appropriate. You should follow your attorney's advice. But your attorney should be next to you at these depositions. He should be making sure that the questions are appropriate and that they're not going into areas that are inappropriate. And he should be watching out for you. So it's very important in these depositions that you keep your answers short and simple. You got to remember that the person who's taking this deposition, although they may be a very nice person, they may seem like your friend, they're not your friend. They're representing the other party. So it's their job to pick apart your case, to get information from you that's going to be beneficial to them. And it just goes to say that if it's beneficial to them, it's not beneficial to you. So what you want to do in these situations is to listen to the question. Wait for the question to be completed. That's a number of reasons for that. Number one, you want the question to be completed before you answer, because the court reporter who's taken everything down can only take one person at a time. You want to be able to have the court reporter get a nice, clean record. Also, it's important that you let the other side finish their question before you start answering it, because you want to make sure that you're answering the question that's being asked. So it's really important that you let that happen. And then when it's time for you to answer, you should be saying to yourself, you should do a mental process in your mind that is as follows. Can I possibly answer this question either yes or no? If the answer to that question is yes, that's all you should be saying. Or if the answer to that question is no, that's all you should be saying. You should never answer a deposition question with yes and let me explain, or no, the reason is this. That's not what you should be doing. It may be obvious that the attorney is going to ask a follow-up question and ask you to explain that. Sometimes they don't. The attorney must ask the question in order to be entitled to the answer. So don't provide them with information that they're not otherwise entitled to. Listen to your attorney. If your attorney objects to a question and tells you not to answer the question, then you should listen to your attorney and not answer the question. Sometimes an attorney will make an objection for the record, and that's for trial, but will say to you, but you can answer the question if you can. In that situation, do the best you can to answer the question. So those are the kind of rules that you need to follow. Also, there will be questions that will be asked of you in a deposition that you don't know the answer to. And the good thing about a deposition is you don't need to study for it. It's not like a test in school where you want to study so that you make sure you get the right answer. A deposition is all about what's up here. If it's not up there, then the attorney isn't entitled to any information. If they ask you a question and you don't know the answer to the question, the correct answer is I don't know, or I don't remember, or I don't recall, or I'm not sure. Whatever the correct answer is in your head, that's the answer. You also never want to say to the attorney, you know, I don't know the answer to that, but I have that information somewhere else. Because then they're just going to follow up with something and they're going to get that information from you. If they ask you the question, do you have that information somewhere else, then of course you have to answer it that way. But your job is not to provide the information to the attorney. Your job is to answer their questions. That's what a deposition is about. It's a pretrial discovery device that is very technical, and the deposition will be used at the time of trial. You better be sure that you do a good job at your deposition, but for a number of reasons. Number one, a deposition is the first time and the only time that the defense attorney gets an opportunity to evaluate you pre-trial. And they're going to write a memo to their insurance adjuster about the deposition when it's over. And the last thing you want them to write is the deponent gets confused. He doesn't follow his attorney's instructions. He talks too much. He's a weak witness. This is the kind of person we want to take to trial because we'll beat him up. That's not the memo that you want him to write to his insurance adjuster. You want the memo to say, this is an excellent witness, well prepared by his attorney, answers questions short and simple. This is the kind of witness we don't want to bring to trial because a jury is really going to like that person. So let's settle this case. That's the memo that we want him to write to the insurance adjuster. So the deposition is really important. So I understand you might be nervous at your deposition, but you'll get over that as you get into it and there is a flow. And you remember that you really can't do poorly if you just answer the questions short and succinctly and keep it to the information that's in your head. And don't try to answer something that you don't know. Never assume. Sometimes people want to make assumptions. A question will be asked, and you think, oh, I assume this must have happened. Never do that. Unless you know the answer is I don't know or I don't recall. So if you follow these rules in a deposition, you'll do a great job. And again, like I said, your deposition will be used at the time of trial. When your case goes to trial and you're up there in the witness box, trust me, the defense attorney is going to have your deposition right next to him. And he's going to have summarized that deposition. And he's going to know page and line where you answered certain questions a certain way. And he's going to ask you the exact same questions that he asked you at your deposition. And if you don't answer those questions pretty much exactly the same, he's going to pull out that deposition and he's going to say to the jury, hey, on this particular day you answered the question this way, but in your deposition that I took a few months ago or a year ago, you answered it this way, and it doesn't look good. So it's really important that you give your best testimony at the time of the deposition and that your testimony is accurate so that when you do testify at the time of trial, you don't give the defense attorney the opportunity to do that. Thank you very much.